Welcome back. This is part 2. What about the scope and the structure of the CISG? The sphere of application of the CISG is regulated in Chapter 1. The basic requirements for the CISG to apply are defined in Article 1. According to Article 1, Paragraph 1, there must be an international sales contract on the one hand, and, in the sense of an alternative condition, one of two specified relationships to the CISG on the other hand. So the contract must be a sale. And it must be a sale of movable goods. In addition, it must be international in the sense of a sale between parties with places of business in different states. Finally, there must be one of two specified relationships to the CISG. The CISG applies if both states involved are parties to the convention, or if the rules of private international law lead to the application of the law of a contracting state, of a state that is a party to the CISG. According to Article 2, certain types of sales contracts are excluded from the sphere of application of the CISG. The most important of those exclusions is the exclusion of sales of goods bought for personal, family or household use according to Article 2, Paragraph A, which means that the CISG does not apply to consumer contracts. Other exclusions mentioned in Article 2 are sales by auction, sales on execution or otherwise by authority of law, sales of stocks, shares, investment securities, negotiable instruments or money, sales of ships, vessels, hovercraft and aircraft, or sales of electricity. On the other hand, the sphere of application of the CISG is somewhat extended by Article 3. According to Paragraph 1, contracts for the supply of goods to be manufactured or produced are to be considered sales unless the party who orders the goods undertakes to supply a substantial part of the materials necessary for such manufacture or production, which means that as a general rule, the CISG also applies to manufacturing contracts. However, according to Paragraph 2, the CISG does not apply to contracts in which the preponderant part of the obligations of the party who furnishes the goods consists in the supply of labor or other services. This shows you that, as far as mixed contracts are concerned, the CISG takes a preponderant part approach. The CISG applies to such mixed contracts as long as the supply of goods remains the preponderant part of the obligations of the seller. Articles 4 and 5 add a number of restrictions to the sphere of application of the CISG. Article 4 makes it clear that the CISG regulates only the formation of the contract of sale on the one hand and the rights and obligations of the parties arising from the contract of sale on the other hand, which reflects what was covered by the ULF and the ULIS that served as a starting point for the drafting of the CISG. Articles 4 and 5 also specify a number of issues that remain outside the scope of the CISG. The CISG does not regulate issues of contract validity, for example, the invalidation of the contract due to error or deception. Furthermore, the CISG does not regulate issues of property transfer. It is not concerned with the property law conditions for transferring the property of the goods sold from the seller to the buyer. Finally, the CISG does not regulate issues of liability for death or injury caused by the goods sold to any person. The CISG does not interfere with national legislation on such product liability issues. You probably remember this case. So what about this case? Assuming that the court in Yverdon is dealing with the dispute. Is the contract governed by the CISG? I invite you to take a couple of minutes to assess the case on the basis of Articles 1 to 5 of the CISG. Does the contract come within the sphere of application of the CISG?